Hello and welcome everyone to our webinar on the legal considerations when running a not-for-profit. My name is Sarah and I'm a lawyer in LegalVision's corporate team. And I'm joined today by my colleague Tom, who is a lawyer in our tax team. Before we begin, I just wanted to run through a couple of quick housekeeping items. So firstly, you will receive the recording and slides in your email to refer to later. Please submit your questions in the chat box during the webinar and we'll answer them at the end. And please also complete the feedback survey after the webinar. Also, just wanted to note that all attendees are eligible to receive a free consultation with us to discuss how we can help you with your contracts or any of your legal needs. To request your free consultation, provide us with your contact details in the survey that appears at the end of this webinar. So today we're going to be discussing running your not-for-profit. So firstly, I'm going to talk about becoming a charity and the benefits of becoming a charity. Then Tom's going to talk about tax concessions for not-for-profits and charities. I'll go through corporate governance for charities and reporting obligations. And then we'll finish with Tom telling you about deductible gift recipients and the question and answer at the end. So to begin, we're going to be talking about what it means to be a not-for-profit and why and how your not-for-profit can become registered as a charity. So it's important to note that charities are a small subset of thousands of not-for-profits that exist in Australia, and you can access some benefits as a not-for-profit without becoming a charity. For example, you might be eligible to access certain tax exemptions and other benefits, which Tom will discuss later. You might also be able to conduct fundraising activities. However, one of the large benefits of being a not-for-profit is that this is one of the eligibility criteria for becoming a registered charity, which has its own set of additional benefits. To be a registered charity in Australia, you need to apply to Australia's charity regulator, which is the Australian Charities and Not-for-Profits Commission, or the ACNC. And you'll need to meet all of the criteria for becoming a charity. The first of which is that your organisation operates as a not-for-profit entity. The other criteria are up on your screen there. You must have a charitable purpose for the public benefit. You must not have a disqualifying purpose and not be an individual person, political party or government entity. So how do you actually demonstrate your not-for-profit status? Well, not-for-profits or NFPs do make profits. In fact, some are very profitable. It's what you do with those profits that counts towards whether you are considered a not-for-profit entity under law. In an NFP, profits need to further the aims or mission of your organisation, even if your business activities might look the same as a for-profit entity. So, for example, you might retain some of your profits for growth, hire new staff, or start new projects. The key point is that you can't be considered an NFP if you distribute any of your profits to members or if members of the entity are entitled to receive any benefits from the profits. So, for example, an NFP can't distribute dividends, members of an NFP can't sell shares or enter into any profit sharing arrangements. So how you actually demonstrate your not-for-profit status is going to depend on the structure of your entity. However, generally the ACNC is going to look to your governing document. So for example, your constitution, rules or bylaws. That governing document needs to include a statement that the entity is operating as a not-for-profit and a winding up clause that states that any remaining funds or assets are to be distributed to another NFP with similar purposes. So the second criteria for becoming a charity is that your entity has a charitable purpose for the public benefit. There is a non-exhaustive list of charitable purposes set out in the Charities Act, which is the key piece of federal legislation governing the operation of charities in Australia. And some examples of those are on your screen now. When actually applying to the ACNC to become a registered charity, you're going to need to be specific about what your entity's charitable purpose is, which is something that a charity lawyer can assist you with. Ultimately, however, it's not going to be enough just to have a charitable purpose. The charitable purpose must also be for the public benefit. Under law, there are certain purposes that are going to be presumed to be for the public benefit, so you don't need to prove that it is. So, for example, relieving poverty, distress or disadvantage, caring for and supporting the aged and people with disabilities, or advancing education or religion are all purposes that are going to be presumed to be for the public benefit. Otherwise, we can look to a test set out in the Charities Act to determine whether the charitable purpose of your organisation is actually for the public benefit. And generally, this would just look to whether the purpose of your organisation is directed to a benefit that is available to a sufficient section of the general public. So to move on, the third criteria for becoming a charity is that your organisation does not work towards a disqualifying purpose. So this means that your organisation is not going to be eligible to become a registered charity if it engages in or promotes purposes which are unlawful or contrary to public policy, or if it promotes or opposes a political party or candidate. This isn't always going to be black and white. So for example, a charity with the main purpose of advancing healthcare might also scrutinise healthcare policies, and that's not going to be a disqualifying purpose. As well, a charity might have a non-charitable purpose, but as long as that's ancillary or incidental to and in furtherance or in aid of your main purpose being a charitable purpose, that is going to be okay and won't be a disqualifying purpose. So finally, the final criteria for becoming a charity is pretty self-explanatory. Individual people, political parties and government entities are not eligible to become charities. So if your organisation is eligible to become a registered charity, the question is, why would you bother going through this process? Well, there are many benefits to becoming a charity. First and foremost, you might be able to access additional tax concessions or be endorsed as a deductible gift recipient, which Tom is going to go through later in this presentation. You'll also be able to display the ACNC registered charity tick, which is going to award a level of confidence in your organisation from the general public. There are streamlined reporting and corporate governance requirements, which I'm going to speak about a bit more later. And finally, there are certain exemptions from requirements under Commonwealth laws for charities. For example, you might be able to play sound recordings without breaching copyright or even send unsolicited emails. However, we do recommend you get legal advice before engaging in any of those activities. So if you do decide that you meet the definition of being a charity and it would benefit your organisation to be registered as such, you can apply to the ACNC. And to put that application in, you're going to need to present your governing documents, which, as I mentioned earlier, will evidence your not-for-profit status. And you'll also need to include information like the location in which you intend to operate, your charity subtype, which is going to reflect the charitable purposes I mentioned earlier, the activities you intend to carry out in furtherance of your charitable purpose, and the people your organisation intends to benefit. You can also apply for DGR endorsement at the application stage, which again, Tom will touch on later. Now, it's worth noting that the ACNC application can be quite detailed depending on what your charitable purpose is. So we recommend seeking legal advice to assist in streamlining this process, which is something we can assist with here at LegalVision. So I'm now going to hand over to Tom, and he's going to discuss the tax concessions available to not-for-profits, some of which you might be able to access before becoming a registered charity.
Great, thanks, Sarah. So as Sarah has canvassed in her section, a not-for-profit organisation can be entitled to a number of tax concessions, which are available at both the federal and also at the state and territory level. So at the federal level, a not-for-profit can be entitled to the income tax exemption, fringe benefits tax exemption or rebate, and certain goods and services tax concessions. If an organisation is planning on becoming a registered charity with the ACNC, it can apply to be endorsed by the ATO to receive these concessions at the same time that it puts in its charity application. If it does not do so at this stage, the organisation is able to apply directly to the ATO at a later stage. So we'll go through some of the concessions in a bit more detail now. So we'll start with the income tax exemption. So if a not-for-profit is able to access the income tax exemption, it will not have to pay income tax, nor will it have to lodge an income tax return at the end of a financial year. All not-for-profits can be eligible for this exemption. Registered charities will need to apply to the ATO for endorsement, whereas other not-for-profits will need to self-assess their eligibility. It's generally recommended that this self-assessment is done on a yearly basis to ensure that the organisation is eligible each financial year. And if your organisation needs assistance with this, we can certainly assist. Broadly, an organisation will qualify for this exemption if it satisfies at least one of 3 tests and qualifies with 2 conditions. The tests are the In Australia test, which means that either the organisation is physically in Australia or incurs expenditure and pursues its objectives primarily in Australia. The Deductible Gift Recipient test, which means that the organisation is endorsed as a DGR in its own right. And finally, the Prescribed by Law test, which means that the organisation has been prescribed by the law as an income tax exempt entity, which basically means that they're listed in the tax legislation as an entity that does not have to pay income tax. The 2 conditions are the governing rules condition, which broadly means that the organisation must comply with the substantive requirements in its governing rules, such as its constitution, bylaws, or any other documents that Sarah mentioned earlier. And finally, the income and assets condition, which means that the organisation must apply its income and its assets solely for its purpose, which for a registered charity must be its charitable purpose, as Sarah mentioned previously. So next, there are the GST concessions. So there are certain GST concessions which are available to non-for-profits, with a larger number available to those not-for-profits which are registered charities. A registered charity will need to be endorsed by the ATO and hold an Australian business number to be eligible for these concessions. And if they do both of these things, there are no additional tests that they must comply with to get the concessions. So we've put all of the concessions on the screen. So as you can see, there are a fair few, but some of the key concessions are the higher turnover threshold. So generally a business must register for GST in a given year when its turnover reaches, its GST turnover reaches over $75,000. This threshold is increased to $150,000 for non-for-profits. Gifts, so if there are no conditions attaching to a gift, it will not be considered payment for a sale, and therefore GST won't be attracted. And then fundraising events, so registered charities endorsed by the ATO can choose to not charge GST on sales it makes in connection with fundraising events. So finally, for the federal concessions are the fringe benefits tax exemption and rebate. So not-for-profit organisations which are eligible for these concessions will either be exempt from fringe benefits tax or be entitled to a fringe benefits tax rebate. Both are subject to a capping threshold in respect of the fringe benefits provided to each of that organisation's employees. Generally, benefits provided above this threshold will still attract fringe benefits tax. To be eligible for the exemption, the organisation must be one of the following: a public benevolent institution other than a public or not-for-profit hospital that have been registered as a charity with the ACNC and then endorsed by the ATO, health promotion charities that have been registered as a charity with the ACNC and endorsed by the ATO, public or not-for-profit hospitals, and public ambulance services. To be eligible for the rebate, the organisation must be one of the following: so charities that are institutions but not a public benevolent institution that are registered with the ACNC and endorsed by the ATO, religious institutions registered by the ACNC and endorsed by the ATO, certain scientific or public educational institutions, trade unions or employer associations, and other types of not-for-profits established to achieve certain outcomes. So if you're not a registered charity, we can certainly give you advice on whether your not-for-profit might be eligible for the FBT rebate. So that's the federal concessions, but there are also state and territory concessions. Each state and territory have different laws in respect of their local taxes, but broadly speaking, there are exemptions from paying payroll tax, land tax, and stamp duty for certain not-for-profit organisations. There are generally conditions attaching to the exemptions, such as the wages being paid must be directly related to the charitable purpose of the organisation in the context of payroll tax, and that the land being acquired must be used for a charitable purpose for the stamp duty exemption. It is important to get advice on how each state and territory's laws would apply to your not-for-profit circumstances, as the laws can differ significantly between the different jurisdictions. So I'll now hand back over to Sarah, who's going to discuss corporate governance for charities.
Excellent, thanks, Tom. So there are a number of corporate governance considerations to be aware of if you are involved in operating a charity. And I'm going to start by discussing your corporate governance responsibilities at law. Now, the various laws that apply to your organisation are going to depend on its structure. However, generally, if you have an incorporated structure, once you become a registered charity, certain provisions in the Corporations Act are switched off. For example, if your organisation is a company limited by guarantee, which is a very common structure used by not-for-profits and charities, you will be reporting primarily to the ACNC rather than to ASIC, and many of the corporate governance provisions in the Corporations Act are not going to apply. However, entities like incorporated associations are still going to have obligations to the relevant state-based regulator. So we recommend seeking advice from a charity law specialist to determine what laws and regulations apply to you. The Corporations Act provisions that are switched off include many of the director's duties and the financial reporting and auditing obligations, along with a whole other range of provisions relating to corporate governance and responsibility. In place of those switched off provisions, the ACNC governance standards will apply, which we're going to go through now. So ACNC governance standard number 1 goes to your purposes and not-for-profit nature. So this means that your charity must operate and continue to operate as a not-for-profit and work towards its charitable purpose. So as I mentioned earlier, you must be able to demonstrate this in your governing document and on your accounts. And you need to also provide information about your purposes to the public. Note that this is an ongoing obligation, so it's not enough to simply operate as a not-for-profit when you apply to the ACNC. You need to continue operating as such. The second ACNC governance standard is accountability to members. So a charity that has members must take reasonable steps to be accountable to those members. This means that you must provide your members with an adequate opportunity to raise concerns about how your charity is governed, and you generally need to be communicating with those members to let them know what's going on in the charity. ACNC Governance Standard 3 is compliance with Australian laws. This means that your charity must not commit a serious offence, and that's defined as an offence that may result in a penalty of 60 penalty units or more. And these are generally quite serious offences. So we definitely recommend speaking with a lawyer if you're concerned that your organisation has breached this governance standard. Governance Standard 4 is suitability of responsible people. So the ACNC uses the phrase responsible people to refer to board or committee members of charities. So they're like directors or committee members. You must ensure that those responsible people are not disqualified from managing a corporation, either under the Corporations Act or being disqualified from being a responsible person of a registered charity by the ACNC. And again, if one of your responsible persons becomes unsuitable to sit in that role while they're in office, you do have an obligation to remove that person. ACNC Governance Standard number 5, Duties of Responsible People, is the really key one to be aware of. It means that your charity must take reasonable steps to ensure its responsible people are subject to, understand, and carry out the duties under this governance standard. The duties of responsible persons are similar to directors' duties under the Corporations Act, which you might be familiar with, and these include acting with reasonable care and diligence, acting honestly and fairly in the best interests of the charity and for its charitable purposes, not misusing their position or information they gain as a responsible person, disclosing conflicts of interest, ensuring that the financial affairs of the charity are managed responsibly, and not allowing the charity to operate while it is insolvent. The ACNC provides a lot of helpful guidance around these duties, so we recommend having a good look at the ACNC website and ensuring that all of the responsible persons of your charity get familiar with the duties under this governance standard. If you have any questions about these duties, this is certainly something that we could assist you with here at LegalVision. Now moving on to ACNC Governance Standard number 6, this is maintaining and enhancing public trust and confidence in the Australian not-for-profit sector. Now, this is quite specific. It means that your charity must take reasonable steps to become a participating non-government institution of the National Redress Scheme if the charity is or likely to be identified as having been involved in the abuse of a person under the National Redress Scheme for institutional child sexual abuse or in response to a request under the National Redress Scheme. The purpose of this governance standard is to maintain and enhance public trust and confidence in the sector by ensuring that a registered charity's governance enables it to be accountable for past conduct relating to institutional child abuse. We definitely recommend seeking additional advice if you think that this might apply to your charity. Aside from the ACNC governance standards, I wanted to briefly mention the reporting obligations for charities. Every charity must submit an annual information statement to the ACNC about the charity, its activities, and basic financial information. This is really to help the ACNC to understand the charity sector and reduce reporting burden for charities. Medium and large charities also have an obligation to submit an annual financial report that is reviewed or audited depending on the size of the charity. The size of a charity is measured by reference to its annual revenue. So if you have annual revenue of over $500,000, which is the minimum required to be considered a medium charity, you should make sure that you familiarise yourself with the financial reporting obligations and seek assistance from a qualified lawyer or accountant if required. So now I'm going to pass back to Tom. He's going to tell you about how to become endorsed as a deductible gift recipient.
Thanks, Sarah. So organisations that are endorsed as deductible gift recipients are entitled to receive donations that are then deductible from the donor's income tax. So this broadly means that when a donor makes a gift or contribution to a DGR endorsed charity, that donor may be able to claim an income tax deduction in their own tax return at the end of the financial year. So not all non-for-profits will want to pursue DGR endorsement, but an organisation may benefit from becoming DGR endorsed for the following reasons. So when it comes to donations and gifts, a donor may be more incentivized to donate money or other property to an organisation with DGR endorsement, given that they can potentially claim an income tax deduction for making that donation. And then with grants, certain grants are only available to organisations with DGR endorsement. So if your organisation decides to pursue DGR endorsements, there are broadly 4 steps that are involved in applying or becoming endorsed. So the first is become a registered charity, following the process that Sarah has set out earlier. So as of December 2021, all non-government DGRs must be a registered charity unless they are specifically listed within the tax law as being a DGR endorsed body, such as Cancer Australia. So the next step is then to fall within one of the general categories of DGR. So we've put all of them on the screen, and as you can see, there are a fair few, but examples are health, education, welfare and rights, and the environment. So within each broad category, there are then subcategories that the organisation must align with to get DGR endorsement. Next step is to meet the in Australia condition. So this is somewhat similar to the income tax exemption requirement, but broadly requires that the organisation is established and operated in Australia and does not necessarily mean that the purposes or beneficiaries of the deductible gift recipient are in Australia. And then finally, if the organisation meets all of those criteria, it then makes an application to the ATO for endorsement. So an organisation can choose to do this as part of its charity registration to the ACNC, or can apply it directly to the ATO at a later stage. In the former case, if it does it as part of its ACNC application, the ACNC will then pass the DGR application on to the ATO for review. So depending on the type of deductible gift recipient, the ATO might ask the charity to complete what's called a schedule with additional information and documents that it has to lodge as part of the application, which includes things like the organisation's constituent documents, such as its constitution, links to its website and marketing materials, information about the people responsible for decision making, and then information about the specific type of endorsement. So it can also be the case that deductible gift recipients are required to maintain a committee of responsible persons to manage the DGR's gift fund. And if so, the schedule will ask for more information and details about these persons and how they actually meet the definition of a responsible person. So an important point to note is that there are currently 4 types of DGR applicants that must apply to separate government departments to be endorsed. They cannot apply to the ATO. So legislation has been passed which consolidates these into the ATO, which takes effect on the 1st of January 2024. So until this stage, the separate applications must still be made. The categories are the Register of Cultural Organisations, which is administered by the Department of Infrastructure, Transport, Regional Development, Communication and the Arts. The Register of Environmental Organisations, which is administered by the Department of Climate Change, Energy, the Environment and Water. The Register of Harm Prevention Charities, which is administered by the Department of Social Services. And finally, the Overseas Aid Gift Deductibility Scheme, which is administered by the Department of Foreign Affairs and Trade. So each has a different application process, which does materially mirror the ATO's application. However, it's important to check each individual application as it may differ. And if you are looking to apply for DGR endorsement in one of those categories before the 1st of January 2024, we can certainly assist with the more bespoke application process. So that concludes the main part of our webinar. You might find our NFP Legal Health Checklist useful. You can download it in the handout panel or by scanning the QR code on the screen. We also have an upcoming event which may be of interest to you, which is Psychosocial Hazards, Understanding Your Responsibilities as an Employer, which is taking place on Thursday, the 5th of October at 11 AM Australian Eastern Daylight Time. We're going to answer your questions shortly, but while you submit them, we'll take a minute to tell you about our membership. LegalVision's membership is a cost-effective alternative to the expensive hourly rates you experience with other law firms. For an affordable monthly fee, you receive cost certainty and all-inclusive legal services, including unlimited document review, including the drafting, amending, and the reviewing of business contracts and your commercial leases. It includes unlimited advice consultations with our team of over 100 specialist lawyers, including business structuring, employment, disputes, and then us in the tax and the not-for-profits team. And it also includes unlimited domestic trademark registrations. As a LegalVision member, you won't worry about the costs of lawyers ever again. Think about it as having your own in-house legal counsel. We'll take care of the business as usual legal work, and so you can focus on running your business. And if you are in-house legal counsel, our membership is a cost-effective solution for outsourcing of additional legal work. To learn more about how the membership can help you, request a free consultation when the survey appears at the end of the webinar. So now we're going to answer some of your questions. Just take a minute to have a look through the ones that have come through.
Thanks, Tom. I'll take the first question. So the first question is, can you please provide an overview or checklist of board member responsibilities? So in terms of the duties of board members under law, we've already touched on this when I was talking about the ACNC governance standards. And when conducting your role as a board member, you need to keep those governance standards in mind as sort of the foundational responsibilities of a board member or a responsible person. However, of course, there are other responsibilities that board members need to keep in mind. And these are going to be different depending on the size and activities of the charity. So if, for example, if you have the resources, your board members might be delegating work to staff and volunteers. However, there are always going to be some responsibilities reserved for these responsible persons. And these will look like things like appointing senior staff members. It might be developing a business plan or calling meetings of members, which you might be required to do depending on the size of your charity. I suppose it's just important to remember that if you're on the board of a charity, you are in charge of the governance of that charity. So you need to be responsible for ensuring that the charity is meeting its obligations, some of which we've spoken about today. You need to make sure it's managing its finances correctly, set goals for the charity and ensure that those goals are in line with what the charitable purpose of the entity is. You might also need to work on securing funding to support the work of your charity. However, as I mentioned, the day-to-day responsibilities of board members are going to look different based on the size of your charity, what activities you're actually undertaking, and what your structure is. So I would recommend having a good look on the ACNC website or booking in a consultation with us, and we can have a chat through what the responsibilities of board members might be for your specific circumstances.
Thanks, Sarah. I'll answer the next one which has come through, which is, what is the capping threshold you mentioned in the fringe benefits tax concessions? And it's a good question. And the answer for a particular organisation will depend on the type of organisation and whether that organisation is looking to qualify for the rebate or the exemption. So with the exemption, the capping threshold is $30,000 per employee for public benevolent institutions and health promotion charities, and $17,000 per employee for hospitals and ambulance services. And then for the rebate, the capping threshold is a flat $30,000 per employee. So what does that actually mean? So what this means is that the grossed up value of the fringe benefits provided to an employee, if that amount is at or less than the capping threshold for the type of organisation, the benefits provided to that particular employee will either be exempt or rebatable, depending on which exemption or which concession, I should say, you're looking to get under. So any benefits that are provided in excess for those capping thresholds will still attract fringe benefits tax at the regular rate. So if you need assistance, you can certainly chat to us about this in more detail, especially if you need assistance with actually what it means to calculate the grossed up value of a fringe benefit.
Excellent, thanks Tom. Someone has just asked a question, which is, a not-for-profit sounds like it cannot be a subsidiary, for example, of a holding company. Is that correct? So that's not necessarily correct. As I mentioned before, one of the most common structures for NFPs and charities is companies limited by guarantee. So those companies are structured in such a way that there aren't any shareholders like you'd see in a regular for-profit entity. So yes, a not-for-profit wouldn't be a subsidiary in that way because it can't have shares, because shares would sort of disqualify it from having a not-for-profit status. However, companies limited by guarantee still have members. It just is structured a little differently. So members guarantee a certain amount, for example, a nominal amount like $10, and that's the amount that they need to contribute to the company if the company is wound up. So theoretically, a holding company could be the sole member of a company limited by guarantee that is a charity. You might just have to be really careful about demonstrating that not-for-profit status, given your sole member would be a for-profit entity, because the ACNC might look at that a little more closely to make sure that you are satisfying all the criteria for being a charity. But it wouldn't necessarily disqualify you to set up a subsidiary charity so long as you have the appropriate structure, which again is something that we can help you with at LegalVision if you are looking to set up a charitable arm of your business.
Right, so one other question that's come through about the tax side of things is, what does it mean for an organisation to have been established in Australia for deductible gift recipients? And so again, another really good question. And when it comes to an organisation having been established in Australia, it really does come down to the facts and circumstances surrounding that particular organisation. The ATO has set out guidance on what this means though, and broadly this requirement would be satisfied where the organisation has either been legally established in Australia, such as a company limited by guarantee, which has been incorporated under the Corporations Act, like what Sarah was discussing before. Alternatively, an organisation would be able to satisfy this where it makes its operational or strategic decisions mainly in Australia. That's quite a broad criteria, and it really goes to, as I said, a lot of the facts and circumstances that are surrounding that organisation and how it's being operated. So if you do need assistance with satisfying this criteria, definitely come and talk to us and we can assist.
Excellent. So we've got another good question come through. It's, what is the difference between NFP organisation strategies and social enterprise structures? So as I said, this is a really good question because sometimes this can be a little bit unclear, because both NFP organisations and social enterprises tend to work towards causes that are for the public benefit or for the good of society in some way. However, it's important to note that an NFP or charity is actually a legally recognised structure, whereas a social enterprise is something a little bit different. It's not recognised under law, it's just something we kind of understand colloquially. So a social enterprise is generally going to refer to an organisation that is run using a commercial business model, but it works towards social objectives. And this means that it's not necessarily going to be a not-for-profit. So some social enterprises will be a not-for-profit, however, some are going to be for-profit or a hybrid of the two. And you really need to sort of look at what the entity is actually doing with its profits and how it engages with its members to determine whether it is a true not-for-profit or not. So a couple of examples of social enterprises that are not NFPs are the brands Thank You and Who Gives a Crap. So you might have seen them in the supermarket. They sell sort of Thank You sells bathroom products, Who Gives a Crap sells toilet paper. These brands are presumably quite profitable, and they're going to distribute some of those profits to their members or investors, but at the same time they have quite a clear social vision, and they might donate a portion of their profits to social causes or advocate for social good. So as you can see, organisations like that, they're guided by a social purpose and they're set up to benefit the public, community and environment, but they are disqualified from calling themselves a not-for-profit if they're distributing those profits back to shareholders or investors.
Right, so another one that's come through around deductible gift recipients is who would actually be considered a responsible person. And so as I mentioned before, a responsible person really relates to the committee of people that are responsible for maintaining the deductible gift recipients gift fund, which is where the money and property that's donated generally is donated to or sits. And depending on the type of DGR that you're applying for, there could be a requirement the majority of people that manage that fund have to be responsible persons. So it really comes down to the specific type of deductible gift recipient category or endorsement that the organisation is applying for, because especially with the 4 other categories that aren't managed by the ATO, there are quite specific requirements in that. But broadly speaking, some of the people that have been identified as fulfilling the criteria of a responsible person are people like clergy and church authorities, justices of the peace, magistrates and judges, lawyers, accountants, doctors, and directors of large public companies. So they're kind of the broad categories that the ATO has provided broad guidance on, saying that these would be considered responsible persons. But as we've said, it really does come down to the particular application. So definitely have a chat to us and we can talk you through what could be considered a responsible person for the particular DGR that you're applying for.
Beautiful, thanks Tom. Someone's just asked a follow-up question based on what I was speaking about before with the social enterprises. So they're wondering what kind of structure does a company like Thank You and Who Gives a Crap fall under? So I'm not sure exactly what company structure Thank You and Who Gives a Crap would have, but when you're looking at the social enterprise model, there are a range of incorporated structures that are available to you. If you're not looking to operate as a not-for-profit, so if it's a social enterprise that operates for profit, you could really set up the company however you like. So it could just be a general company limited by shares, and you could bring on investors and have shareholders and that sort of thing. But if you are looking to operate as a not-for-profit, there are additional structures that are available to you. So as I mentioned, companies limited by guarantee. Generally, if you're looking to operate by generating profits, you wouldn't incorporate as a company limited by guarantee. And then there are other structures that are only available to organisations that are not-for-profit. So that includes incorporated associations. So you couldn't operate a for-profit social enterprise as a incorporated association because you have to be not-for-profit. So hopefully that helps and makes sense. Sorry, I'm just checking to see if we have any more questions. I think that really brings us to the end of the presentation today. So some of the questions were a little bit too specific to answer during this session. So if you would like to take advantage of the complimentary legal consultation, we can discuss this with you in further detail. Yeah, as I said, that's all the time we have for today. After the webinar ends, a survey will pop up. We would really appreciate if you could complete the 30-second survey, and please do include your contact details in that survey to receive a complimentary legal consultation to discuss how we can help you with running your not-for-profit or charity or setting up a not-for-profit or charity. Thank you so much for joining us.
Thanks, everybody.